for hanging in here with us through the end of the day. And before I start us off, actually, I just want to speak half a second to a question that was asked during the Q&A during the lunch presentation, because somebody asked about Chaldean students at Wayne Law. And I want to say that something I'm really proud of is the broad representation at Wayne Law of students from all segments of Detroit's Middle Eastern community. And it's one of the things that helps me think that we're really making a difference here. But, okay, so travel ban panel. We've got 3 terrific panelists here with us. You may have noticed from your materials that your materials list 4. Our 4th member taught yesterday afternoon in Colorado, was all set to get on a plane from Colorado to Detroit in the black early hours of this morning, and through a combination of a flat tire and the Transportation Security Administration, turned out not to be able to make her plane. So she's not here with us today, but I am going to do my best actually to pass on to you some of the gist of what she would have said had she been here, because I think it's good stuff and I don't want you all to miss out. That said, people who are here, which is even better, we have Professor SHOBA WADHIA. She teaches immigration and asylum and refugee law at Penn State. She also runs the nationally prominent Penn State Center for Immigrants' Rights Clinic. Before going into teaching, she was Deputy Director for Legal Affairs at the National Immigration Forum. Before that, she was an immigration lawyer in private practice. Her research focuses on the intersection of race, national security, and immigration, and on the role of prosecutorial discretion in immigration law. She has been absolutely tireless as a public advocate for sane immigration laws. She has written a terrific, indispensable book on prosecutorial discretion in immigration law called Beyond Deportation, the book of prosecutorial the role of prosecutorial discretion in immigration cases. It is new in paperback in 2017. It is the Bible on its topic. I believe that she has some copies with her, cheap at the $20 price, and I assume that she would be happy to autograph them for you if so requested. Also on the panel, Professor Marty LEDERMAN teaches at Georgetown Law School. He is one of the country's most insightful voices on matters of separation of powers and national security law. And he's a kid from Detroit. Before going into teaching, he was Deputy Assistant Attorney General at the Department of Justice Office of Legal Counsel. Before he was in government, he was at the DC law firm of Bredhoff and Kaiser. He clerked for Frank Coffin on the First Circuit and for Jack Weinstein in the Eastern District of New York. And his most recent scholarship in the Columbia and Georgetown Law Reviews relates to trial by military tribunals. We have Jan Ting here, who teaches citizenship and immigration law at Temple University. He was Assistant Commissioner of the Immigration and Nationalization Service back in those pre-9/11 days when we had an Immigration and Naturalization Service. He was the Republican Party's candidate for Senate in Delaware in 2006. He's a board member of the Center for Immigration Studies, and he too is a local kid. Grew up in the Detroit area with a dad who had a faculty appointment at the Wayne State Med School. So this is just this is old home week on this panel. This is great.
Where'd you grow up? What is now Dearborn Heights. In those days, it was unincorporated.
Oak Park.
And
Locals.
Ming Chen is not here. She is still back in Colorado, where she teaches at the University of Colorado, and I cannot do her work justice because she is many things I am not, including a Berkeley PhD. But we'll see what we can do with that. In the meantime, I'm going to turn the floor over to SHOBA.
Thank you, Professor Weinberg, for that generous introduction, and good afternoon. We are the last panel, but hopefully not the least, on this Friday afternoon. Thank you to Wayne State, to the Levin Center, and to John Weinberg for inviting me to be on this panel. It's really an honor, and it's been such a learning and inspirational day. I think the dots that have been connected even between the panels have been pretty striking, and I hope that we can continue to connect that dot with this last panel this afternoon. I am here to help set up what you could call the travel ban, what I call the Muslim ban, what you can all think about what it should be called. I also want to break down some terminology that we've heard so far throughout the day, as well as what we might hear in this panel, knowing that this is a mixed audience. So the INA has been thrown around a lot, and it stands for the Immigration and Nationality Act. It is a statute that was passed by Congress in 1952, and it remains the seminal framework for immigration law today. It has been compared second in complication to the U.S. tax code. Executive orders. We've heard about the executive order as it relates to sanctuary. We'll hear about executive orders today. They are different from legislation. They come out of the executive branch. They are signed by the president. They have binding authority. A close cousin to executive orders is the proclamation. And a proclamation is announced by the president, and again, it is a cousin to the extent that it comes out of the executive branch and has some type of a binding nature, and the jurisprudence is not definite on how less or equally binding it is to an executive order. Immigrant. This is a formal term of art in immigration law, and it pertains to those who are seeking admission on a permanent basis. So through employment, through a family relationship, through the diversity lottery program. These are three ways in which someone can acquire immigrant status. Non-immigrant. Non-immigrant refers to someone seeking admission temporarily, a student, a scholar, a Fulbright, a business person, a tourist. These are non-immigrant classifications. And then finally, let me just mention DACA. Many people with DACA, which stands for the Deferred Action for Childhood Arrivals, identify as DACA-mented. But they do not have a formal legal status. They have temporary protection from deportation, a type of discretion, not too different from what Margot talked about earlier with Iraqis who have orders of supervision, or did. Orders of supervision are also a type of discretion, prosecutorial discretion, and they protect someone from deportation. And in the case of OSUPs, that happens after they've been granted or been ordered removed. So what am I going to talk about in my few minutes here to set the stage? Talk about some of the proposals by the president, the executive orders and proclamations, and then tie it into my own reflections between the aftermath of 9/11, during which I spent a lot of time in the Dearborn, Detroit area, and today. President Donald J. Trump first announced his proposal to shut down Muslim immigration to the United States in December 2015. And it lacked much detail, his plan, but there were several debates and discussions among the media, immigration scholars, pundits, communities, and his proposal included many quotations and passages, including a brand on his website that stayed on the website through the campaign trail and after inauguration. To give you one passage of sentiment he shared, each year the United States permanently admits more than 100,000 immigrants from the Middle East and many more Muslim countries outside the Middle East. Our government has been admitting ever-growing numbers year after year without any effective plan for security, end quote. So what can I tell you about the bans? It's almost like a computer program. There's 1.0, 2.0, 3.0, and 4.0. So travel ban 1.0 was signed at 4:30 p.m. on January 27th, a Friday afternoon, 7 days after Inauguration Day. The most controversial pieces of this ban suspends entry for individuals from 7 countries. All 7 countries have Muslim populations of 90% or more. So it is my view that you can accurately call this a Muslim ban because the vast majority of people who are affected by it come from countries with Muslim populations of 90% or more. By its terms, this order also suspended our refugee admissions program for 120 days, indefinitely suspended Syrian refugee admissions, cut refugee numbers by half. Travel ban 2.0 was signed on March 6th, 2017, and since some of us work on semesters, it was also the first day of spring break at Penn State Law. Perhaps it was for you as well. As alluded to by Senator Levin, this was the second list during which Iraq was dropped, and it was on the heels of this second version that the Iraqi arrests, deportations, detentions took place. There was still a 120-day ban on refugees. However, some of the differences included a drop in Iraq, a drop in the indefinite ban on Syrian refugees, and a delay in the effective date. And this effective date delay is important because with respect to the first travel ban, the effective date was immediate. And so what that caused was chaos in airports and in law school clinics all across the country. Penn State University is the 4th most affected university in the country by the first ban. We fielded a couple of hundred calls in the first week of its signature, and in our first community forum had nearly 300 people. And so purportedly to avoid this chaos, there was a delay in the effective date with travel ban 2.0. Travel ban 3.0. This was announced as a presidential proclamation. So while the 2 first versions were executive orders, the 3rd version was a presidential proclamation, and it included country-specific restrictions. And so here the goal by the administration was to, rather than be categorical about who would be blocked from entry in the United States, be specific about the categories. Highlighted in orange here are some of the new countries that were introduced to the list with the proclamation, and you'll also note that Sudan was dropped. Though there were country-based restrictions, many of these restrictions were categorical. So, for example, you'll see that for some of the countries on the list, all immigrants and non-immigrants, which is why I flagged the terminology earlier, were blocked. And with respect to many others, all immigrants were blocked. And that's going to matter later when Professors Ting and LEDERMAN talk about the litigation, because we do have something called a non-discrimination clause in the Immigration and Nationality Act that is very specific to not discriminating people on the basis of nationality and citizenship when it comes to the issuance of immigrant visas. But I have no opinion. Okay, so one other thing I want to tell you about refugees, because the first 2 versions did include a suspension on refugees, is that it leaves this impression to the American public that we don't have a safe and secure system for refugees. And refugee protection is no slam dunk. For anyone who is a refugee and has been through the process, or who teaches this area of law, or who represents refugees, they are one of the most heavily screened immigrant populations into the United States. And not only are they screened through a variety of security checks, they have to meet the legal definition of a refugee, which includes a person who has suffered persecution or will face persecution in the future on account of race, religion, nationality, political opinion, or membership in a particular social group. This harm has to be perpetrated by the government or a group that the government is unwilling or unable to control. So refugee protection is not available to everyone fleeing harm or civil war or anyone who has suffered harm that is less than persecution. What some people call travel ban or an other ban 4.0 is fairly recent. It was signed as an executive order on October 24th, and it includes a resumption of the refugee admissions program. That date, October 24th, is directly tied to the expiration date on the 120-day suspension under Travel Ban 2.0. It also includes some greater restrictions for certain refugees who are seeking admission from 11 designated countries. So one question I'll leave you with before I get to my reflections on 9/11 and turn it over to our panelists is for you to think about what we should call these bans. It's been called a travel ban, a Muslim ban, a refugee ban, and unlike the good immigrant DACA debate, this is a more complicated conversation for some. And the labeling and the words really matter. So something for you to think about, and perhaps we can discuss it in the Q&A. So I'm going to end with a flashback, and that is a flashback to 9/11. The idea of banning people based on nationality, citizenship, religion, race, this is not something new. It predates the current administration. As one illustration, many of the policies that were handed down by the executive branch in the wake of 9/11 were dubbed as national security programs, but they were a direct reaction to 9/11, and they directly impacted Muslim, Arab, and South Asian communities. And I'll use two programs as an example. One program is called Special Interest Detainees, and this was with respect to 1,200 or so detainees who were swept after 9/11 and placed in immigration, or rather federal facilities. And as summarized by then Department of General Office of the Inspector General Glenn Fine, quote, "One of the principal responses by law enforcement authorities after the September 11th attacks was to use the federal immigration laws to detain aliens suspected of having possible ties to terrorism. Within 2 months of the attacks, law enforcement authorities had detained, at least for questioning, more than 1,200 citizens and aliens nationwide." And the fallout of these detentions did not go unnoticed, as the OIG documented major concerns with this detention program, including but not limited to deplorable conditions of confinement, limited access to counsel, lack of notice to non-citizens about the reasons for why they were being detained. And of the 762 detainees who were interviewed by the Office of the Inspector General, the majority were from Muslim-majority countries, with the largest number coming from Pakistan and Egypt. The second and final program I want to highlight as a 9/11 reflection is special registration, or NSEERS, the National Security Entry-Exit Registration System, certainly a program that impacted the Detroit and Dearborn community in significant ways. And this is a policy that required nationals from 25 countries, 24 of which had Muslim-majority populations, to undergo a registration process that involved interrogation, fingerprints, photographs. It remained operational until 2011. One controversial program of the NSEERS program was a call-in program that required certain males who were already living in the United States to visit a local immigration office for an in-depth interview. More than 13,000 of these individuals who came forward were placed in removal proceedings for largely immigration visa violations. In other words, in exchange for voluntarily reporting to a local immigration office to support national security, scores of young men were served with charging documents called a notice to appear that led to their deportation. James W. Ziegler, former commissioner of the Immigration and Naturalization Service, questioned whether NSEERS was really effective. He stated, quote, "The question was, what we're going to get for all of this? The people who could be identified as terrorists weren't going to show up. This project was a huge exercise and cost us resources in the field that could have been much better deployed," end quote. The legality of NSEERS was unsuccessfully challenged on constitutional grounds by several circuit courts. Many did not register because, as I sometimes told the press and government officials, 16-year-olds don't read the Federal Register with their breakfast. The saga of NSEERS continued for more than a decade and affected many people, including men seeking green cards based on a qualifying relationship to an employer or family member who were years later questioned and denied because of a failure to register under NSEERS. NSEERS was discontinued in 2011, but the regulatory structure remained intact, as did the penalty scheme of deportation until December of last year, following a full court effort in front of and behind the scenes. Having worked closely in challenging and defending individuals impacted by immigration directives issued after 9/11, my own take is that proposals under the current administration continue a tradition of exclusion and selective enforcement against Muslim, Arab, and South Asian communities. Then and now, immigration restriction proposals based on religion, nationality, and citizenship raise important questions about legality, morality, and identity. I look forward to questions from our panelists and a discussion with all of you. Thank you.
It's all yours.
Is it okay if I stay at the table? Can you all hear me? I know. All right, great. It is a singular pleasure and honor to be here back home. I love this city. Senator Levin was my senator for many years, and we've had some great senators. I grew up with Phil Hart as my senator, as my model, and then following with Senator Levin, a young boy. Very few young people are so lucky as to have such representatives and such public servants representing them and representing the nation as a whole, and really feeling that their responsibilities both to their constituency and to the excuse me, and to the nation, and working so hard and diligently behind the scenes. Really not until you start working in government do you realize the kind of efforts that go, we see our public officials out there on the screens or the internet speaking, and that's an important part of their role, but the day-to-day work that goes on is quite extraordinary, particularly with respect to public servants such as Senator Hart, Senator Levin, and it's a great honor to be back in Detroit and at Wayne State for this panel. Now, I am somewhat of an outlier here in this symposium today. By the way, it's incredible to me that the audience here, you guys have all stayed on Veterans Day Friday afternoon. If you, an academic, you get placed on the Friday afternoon panel. It's basically, well, there'll be 3 or 4 people remaining, and we thought we'd put you there. But this is fantastic, and it's to your credit that you're so interested. Obviously, Detroit, these issues hit home in Detroit and at Wayne State and in the Midwest generally. So I'm at a disadvantage in that I'm a generalist. I'm not an immigration scholar. I never took an immigration law course, but I'm now going to sign up for Professor WADHIA's course, having seen that. I've been admiring her scholarship and her work online, but boy, I want to take that course to understand this. I was in the Office of Legal Counsel at the Department of Justice, where we had to deal with immigration law and tax law and everything else under the sun. Worked with Senator Levin's staff, as a matter of fact, very closely at trying to do our best to make some good of the military commission system. Hasn't turned out quite that well, but I think the work that we did made it a whole lot better than it had been. And I'm a generalist, and I worked in an office that was a generalist office, and I had to deal with a lot of specific immigration issues, but didn't have nearly the sort of depth that Professor WADHIA has, or my fellow panelists have. But there's an advantage to being a generalist in that you can sort of step back from things. You're not in the crucible of, you're not in the echo chamber of all the people dealing with it every day, and so you can get a sense of, in particular, how generalist judges and justices are likely to view questions. And so I was deeply involved. I was very interested in President Obama's DACA and DAPA programs, and have got deeply into the weeds of those statutes and that litigation to try to figure out what was going on with that, and then with the travel ban as well. I've done so, and so what Jonathan asked me to do is play the role of sort of the generalist looking at the litigation as it exists now and giving a sense of where it might go, a bit of prediction. I'm always a little reluctant to do that because my track record is not very good on predictions, but I'm going to give it a try, and I'm going to, in particular, offer some caution, because I don't think it's at all obvious that the courts will ultimately strike down or cut back on this latest ban the way they did the first ones, although it remains to be seen. I think it could go either way. But I want to lower everyone's expectations so that if there's good news at the end, you can all be very excited. But if there's bad news, you can say, I told you so. So where are we? I'll do just a tiny bit. SHOBA did such a great job teeing up the history in not just a nutshell, like a Brazil nutshell, like a huge, that was great. I can't believe you did all that in such a short period of time. What most of Americans think of as the travel ban or the Muslim ban, I actually call it the entry ban, because it's denying entry specifically, was these first two that were issued in January and March respectively. The January ban was immediately challenged in court. It was incredibly inspirational to see law students and young lawyers on the floors of airports during those first 48 to 72 hours writing up complaints and habeas petitions. It was really a remarkable, inspiring thing. And it worked, because it was really a really poorly thought out, obviously, piece of work by the president. And it got enjoined by lower courts quite quickly altogether. And then it really was a travel ban. People traveling from the United States overseas were not being allowed back in, and it was crazy. And that's why you had all these scenes at the airport. And one thing a question I'm interested in that I'm not sure we know the answer to, it seems to me that those first 2 months, the work of the lawyers and the law students did an enormous amount of good. A lot of people were allowed back into the United States or to enter the United States for the first time because of that successful challenge to EO1. I don't know the exact numbers. Then there was EO2, which had a little bit, travel ban 2.0, which had a little bit more rationality behind it, but not a whole lot. And that was the subject of most of the Sturm und Drang and the litigation throughout the summer, from March until the court recently dismissed those cases as moot, which most of us thought was what was going to happen. Because those were, by their very terms, limitations that were put in place during this 60-day process that the Department of Homeland Security and the State Department were engaged in to allegedly, and they did, very quietly, but they did send out feelers and diplomats to every nation in the world to figure out exactly what the ID management and information sharing practices were for every nation on earth with respect to people who might come to the United States from those nations. And I was actually a bit surprised that they actually finished this process by September and October, but they purported to do so. And so most of the litigation, including going all the way up to the Supreme Court for those 6 months or so, was really all about what would happen during those 6 months. And it was largely successful. Again, the lower courts imposed injunctions on the ban, on 2.0, that would cut back a little bit by the Supreme Court with respect to a particular certain refugee classes. I think that had a very, very important practical impact. I mean, I don't know whether you have any new information, anyone, about one interesting thing is we don't really have a good sense of how many people were allowed to get visas or come into the United States because of the successful action of the challenges to 1.0 and 2.0. But my sense is that quite a few, and every one of them is an important personal case. So then finally they complete this process. The president issues the proclamation that what SHOBA calls 3.0. Just as an aside, I don't think there's any legal difference between a proclamation and an executive order in terms of its legal effect. I think they called it a proclamation only because the statute that they're relying upon refers to proclamation, and they wanted to get rid of that little argument that might be raised against it. But it has the same effect, and SHOBA had a great slide showing you that there are 8 countries now that are affected. 2 of the original countries, Sudan and Iraq, are not. There are 3 new nations, North Korea, Venezuela, and Chad, that are affected in various ways. They wisely, from a litigation perspective, they wisely decided to differentiate somewhat among these nations and to have something of at least a fig leaf of an explanation for why they're treating different nations in different ways, some of them with categorical bans on immigrants, others with categorical bans on non-immigrants. Others have bans of some sorts of non-immigrants or as to some officials over certain periods. And so it looks a lot less arbitrary. It looks a lot less undifferentiated. And it is, right? To its credit, there seems to be at least some thought that went into the tailoring of 3.0. And so my principal purpose here is to describe what the state of the litigation is with respect to the challenges to 3.0, which is the ban that's currently in place as to these new 8 nations. And there's 2 principal lawsuits, and they're the same lawsuits that were going on throughout the summer. There's one out in Hawaii that'll go through the 9th Circuit. That's the lead lawyers are at Hogan and Hartson. Neil Katyal, my colleague at Georgetown and former acting Solicitor General, is the lead lawyer on that one. And then there's a case in the 4th Circuit brought by the ACLU on behalf of the Immigration Refugee Assistance Project, IRAP, and other plaintiffs, that's led by the ACLU and my colleague David Cole and others, challenging that program. And both of them were successful at getting district court judges, trial court judges, to issue injunctions stopping 3.0 in September, or early October, putting nationwide injunctions, and that's an issue we can talk about if anyone's interested in. It's an interesting sort of legal issue that's percolating these days. What's the power of trial judges to impose injunctions that apply to protect not only the plaintiffs in the case, but people all over the United States who might not be in the case before them? We can talk about them. And they issued these injunctions based on different, somewhat overlapping, but mostly different rationales. And those cases both went quickly up to the courts of appeals, where the Department of Justice filed briefs last week to appeal these injunctions in both the 9th Circuit and the 4th Circuit. I have the schedule here somewhere, but I believe both are being argued in early December or around then. And I can imagine by about the 1st of the year, we will probably see opinions from these 2 courts of appeals as to entry ban 3.0. Okay, so now I'm going to get a little bit in the weeds, and I apologize to the non-law students and non-lawyers in the audience for this, but just it'll give you a sense of what's going on. Most of you know that the principal challenge to all of these orders, or the one that's gotten the most publicity or attention, is a claim that it's really a form of religious discrimination, anti-Muslim, right? It's discrimination against Muslims, and that's what it was deliberately designed as, and that in theory violates the Establishment Clause of the First Amendment to the United States Constitution. The Congress cannot establish a religion, right? That discrimination either in favor of a particular religion, if Congress, established a particular church as the Church of the United States, that would be the classic Establishment Clause violation, or the Supreme Court has said, at least in dicta, or to disparage or disfavor an entire religion on its face would be a violation of the First Amendment, at least in certain circumstances. Now here the discrimination is against non-citizens and against people who are not U.S. residents who are not even in the United States for the most part. For the most part, they're overseas, so this raises just a deep, sort of what used to be an academic question of the extent to which First Amendment protections apply to people overseas if the government is in fact discriminating against them. I want to say right at the outset, one really interesting thing is even the Trump administration has not argued for what we might call a very strong plenary power authorization to be able to discriminate on the basis of religion, even as to persons overseas who are not U.S. persons. In fact, the acting Solicitor General appeared to disclaim that idea and to say that even if religion were a fair proxy for some other legitimate basis for exclusion, it would be unconstitutional to actually have a Muslim ban, or to say that we're going to exclude Muslims because there's a correlation, obviously not even remotely, most or all Muslims are associated with terrorism, but most of the terrorist organizations with which we're in armed conflicts with right now are based in Islam, and so there's a correlation at least at that small level, and the government has basically conceded it could not do that. Instead, it says this is not based on religion, it's based on other criteria, other factors. And that's the basic substance of the constitutional or establishment clause claims in these two cases. That one party says this is obviously designed, even though it doesn't say religion on its face, it was designed to discriminate against Muslims. That's the reason for it. And all this other stuff is pretextual. It's all window dressing to hide the ball, right? That really what's going on here is the president had an animus against Islam and against Muslims. I actually have a somewhat slightly different take on this, which is I don't know or frankly care what Donald J. Trump's motivation or what's in his heart of hearts. So the government has come out and said it's not the place of the courts to psychoanalyze the chief executive to see what his motives are. And I agree with that. But what seems obvious to me, and what I think seems obvious to virtually every judge in America who's thought about it, is that this was done, at least in the first instance, and probably still to this day, it was done to fulfill a campaign promise that was made in expressly religious terms to a constituency that does discriminate on the basis of religion, that has anxieties or fears or hostility toward Muslims. And he exploited that during the election. He said he would impose a Muslim ban. And what he's doing, and he's sent a lot of signals to this effect to his constituencies, is he's doing it, I'm not sure what his motivation is, but I do know that I think he is trying to fulfill a campaign promise that was, by its terms, religiously discriminatory. And I think most people think that. Why do they think that? Well, in part because this was so procedurally irregular. There was no, he does it right when he gets into office without checking with anyone, without looking at any of the evidence, without going through the usual running the traps that you would run with all of the people in the executive branch who have been dealing with these problems every day for 15 years, Senator Levin among them, but obviously all the great both career and political officials in the Department of Homeland Security and the State Department and the intelligence community and the Defense Department. And it's not as though they weren't doing anything. Congress and the executive branch imposed over the 15 years before January an extraordinary, elaborate, detailed set of conditions and restrictions and processes to try to make sure that people who might commit terrorist acts would not be allowed to enter the United States. And what do you know? Those practices worked. So there wasn't any evidence of any entrant from any of these nations committing any terrorist acts in the United States except one Somali who entered the United States at the age of 3 and did an attempted terrorist act at the age of 17, right? But no one who had been radicalized overseas has since 9/11 come into the United States and committed a terrorist act. So this seemed to be a pronouncement, an executive order, without a problem to be addressed and without any of the processes you would ordinarily use to try to figure out what you need to do if there is a problem. And it's because of the absence of any factual and procedural predicate that I think it was fair for everyone to conclude, as I just described, that this is best explained, perhaps only explained, as an actual effort by the president to make good on a campaign promise of basically trying to keep Muslims out of America because his constituents fear that. Now, here's the problem. There's two problems. One is under the Constitution, the courts have traditionally deferred very strongly to the executive branch and Congress with respect to judgments about national security, diplomacy, and the like, especially when it comes to entry into the United States and immigration. The legal doctrines in court cases are not entirely deferential, but they're extraordinarily deferential. And the president was exploiting that deference. He knew that. His policymakers knew that the courts would be deferential, as they ought to be in the mine run of cases. And so they have naturally in the litigation invoked all these doctrines of deference. You must defer to the president's, he's entitled to the utmost deference for his judgments about national security matters. So that rings hollow, I think, to most of us, right? I don't think anyone thinks Donald Trump made a serious national security judgment with respect to this, even after the 6-month process. So what we have here is something of a problem. We have a policy that is one thing that almost everyone agrees is one thing and is being done for one reason. And you have a deep and understandable and historical reluctance of the judiciary to call out the president and say, no, you don't really mean that. What you're doing, we're going to call this for what it is. That's as it ought to be. The judiciary shouldn't be second-guessing the president and saying, we don't believe you. And so that's the reason why, to be quick about the constitutional question, I do not think that this case will be resolved with a holding that this violates the Establishment Clause. For well over 60 years, the Supreme Court has always avoided constitutional decisions in this area by turning to statutory arguments, questions about whether there was statutory authority, even when it had to really stretch the statutory language to do so. The court is going to be deeply reluctant to make inroads on these great doctrines of extensive deference that I just described. And so I think I've been saying, and many people have been saying all along, that the case, if the plaintiffs win and if this is struck down, it will be on statutory, not constitutional grounds. And here's the problem with that. SHOBA mentioned that the Immigration and Nationality Act was enacted in 1952, the McCarran-Walter Act, at a time of McCarthyism and deep, deep distrust of, at that time, communism and Central European entrance into the United States, over President Truman's veto, so supermajorities of both houses of Congress. And Jonathan, I hope we have time at the very end. I'd like to quote from President Truman's veto because I think it really resonates here, but it brings out some of the themes that SHOBA was talking about. And that statute had a bunch of nationality-based restrictions. That's what Truman didn't like about it. He thought that it was really against everything that we stand for in America to do that sort of thing. And Congress has largely over the years gotten rid of most of those nationality restrictions. But they also put in place an extraordinary delegation to the president himself, not to agents of the president, but to the president himself. Section 1182F. Which seems to be almost categorical in the language that it uses to give the president extraordinary powers. I actually lost my tab for it, but you can take my word for it. It basically says that the president may, upon a proclamation that the entry of any persons or classes of persons would be detrimental to the national interest of the United States, may impose conditions or restrictions on their entry into the United States. It's about as unconditional as a statutory delegation gets on its face. And President Trump naturally is relying on that too. That's the main authority that he cites for what he's done here. And if you look at the language of it on its face, it would seem to support his view. So he's taking advantage of the fact that Congress gave him a broad delegation and that the courts have historically given him broad deference. He's trying to exploit those two things, which is what good lawyers and good presidents do when they're trying to support their policies. And the really interesting question is whether the courts will put limits on this 1182F authority. And in short, I think we should break it down into what SHOBA described as the immigrants and the non-immigrants. I think as to the immigrant ban, the bans on the actual immigrants coming into the United States or obtaining visas, the courts may very well hold that this 1965 statute, which is a broad prohibition on nationality-based discrimination, trumps this 1952 delegation to the president and does not allow for the type of nationality-based discrimination that's on the face of this proclamation. I'm not sure what the odds of that are, but I think that's the strongest argument that the plaintiffs have. If they win anything at all, that will be the first thing they win on, is that the immigrant bans will be declared unlawful under this 1965 statute. Now, as to the non-immigrants, the 1965 statute doesn't apply. So you just have this very broad presidential authority that Congress has given him. And so far, the courts have not really come to terms with Neil Kochell's. I got to
Good time for a wrap-up.
Okay, I'm wrapping it up. The basic argument is he says that in 1952, Congress was basically codifying a practice that had developed over many decades. There was a very limited presidential authority to act only in times of emergency when Congress didn't have time to deal with an emergent problem, or in wartime, or with respect to discrete particular terrorists or people who are making war against the United States. And that the court should read that statute, contrary to its terms perhaps, to be so limited, and that this doesn't come within that limited reading of the statute. That's, I think, the hardest question in the case. But if I had to predict if the plaintiffs win, it will be on that theory, which has not really been tested in the lower courts yet, but is the best chance of winning. But I have to say, 3.0, because of the 6-month study and the much more, what appears to be the much greater tailoring of the restrictions to each country and the problems that they found with each country's identification processes and the like, the courts are going to be very reluctant to strike it down and to say, even though it looks fine, we know that what was really going on here is what we all do know was really going on here, which is the president making good on this discriminatory campaign promise.
Mr. Ting.
Well, I get to do cleanup. Professor Weinberg says I can take equal time, so that's good, because I want to start by thanking all the usual suspects for putting together this conference. And as for Martin, it's been a great experience coming back. One of my childhood friends is here who's reminisced with me about going to the International Institute, which is on Wayne State's campus, as immigrant children. Children of immigrants often hung out there. You know, our parents got support at the International Institute, and we as kids remembered running around at the International Institute, and it's still there on the same block as the Inn on Ferry Street where they're putting us up. So that was a great memory to have. Another memory was that even though my father was a University of Michigan Medical School graduate and enlisted in the U.S. Army in 1943 when he graduated, even though the Chinese Exclusion Act was still in effect, which said Chinese could not immigrate to the United States or become citizens, but they could come as students, which is how both my father and my mother came to the United States as students, knowing they could never stay and would have to go back. But as soon as he graduated from medical school, he enlisted in the U.S. Army. He returned as a U.S. combat veteran, having served as a medical officer, and got a job working as a physician in Dearborn, Michigan. And even though he was a Michigan medical school graduate, combat veteran of World War II, with a job working as a doctor in Dearborn, he was not allowed to buy a house in Dearborn, which had a white Dearborn policy. The motto was, "Keep Dearborn clean." Everyone knew what that meant in Dearborn, Michigan. And so, you know, in those days, they could just say to your face, "We can't sell you this house." Right? We'd be fired if we sold you this house. You're not going to be able to buy a house in Dearborn. So what did they do? So they bought in the unincorporated area outside Dearborn. Who buys homes in unincorporated areas? And the answer is immigrant auto workers, people that came from all over the world to work in the auto plants. Those are the best paying industrial jobs in the world, right here in Detroit. And so I grew up with the sons and daughters of immigrant auto workers. And it was a great experience, one I always treasure. I come back to all my high school reunions, and in the most recent one in 2016, they were all sharing with me why they were going to vote for Donald J. Trump. Right? And Dearborn and Michigan, of course, was one of the 6 states that voted for President Obama twice in 2008 and 2012 and switched over into the Trump column in 2016. That's part of the reality. The second reason I want to thank you for inviting me is because it's been a great conference, really. I mean, each plenary has been like better than the one before, and the first one was great, you know, and the second one was greater than that, and the third one was really a hard act to follow, but that's the position that we're in. And I appreciate everyone kind of sharing their consciences, and I hope everyone was listening to what was said, because a lot of good stuff was said, so I'm grateful for that too. It seems to me, in summing up, that the basic immigration issue is not whether we should admire and respect immigrants, as some people say it is. Of course we should admire and respect immigrants. Every American family has an immigrant story, or more, right? Several immigrant stories. So we're all descendants of immigrants. Even Native Americans are descendants of ancestors that came here from somewhere else. We share that common heritage. So the question is not whether we should admire and respect immigrants. The question is, given the fact that we should admire and respect immigrants, how many should we take? Should we take everyone who wants to come here without limitation? Or should we say, no, we can't take everyone. We have to enforce some kind of limitation, even though it means turning away people who are good people, who are not criminals or terrorists, who just want to work hard to make a better life for their families, like our immigrant ancestors. We have to turn them away because we can't take everybody. Which is it? That is the great divide in immigration that divides us today. And you know, I'm a lawyer. I can argue both sides of that one, and I have. But if you're on the side that says we can't take everyone, and that we have to enforce a limitation, even though it means turning away people like our own ancestors, I can predict your position on every issue. I can predict your position on DACA, on immigrant detention. I can predict your position on sanctuary cities, and I can predict your position on the travel ban. And conversely, if you're on the other side, if you're among the people who say, we should not have immigration laws that result in the deportation of good people who just want their shot at the American dream, who are hardworking like our own ancestors, we should not have immigration laws like that. If that's your view, I can predict your position on every issue. I know what you think on DACA. I know what you think on immigrant detention. I know what you think on sanctuary cities. And I know what you think about the travel ban. So that's how binary the split on immigration is. I can predict your positions on all of those issues. Let me just say that this statute that Marty was referring to, I mean, immigration lawyers refer to it as INA Section 212F, but it's the same statute. And I think the language is important. Let me read you the language of that statute. Whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation, right? Somebody raised the question, oh, they're calling it a proclamation now. Oh, well, that's to conform with 212F. He may by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or of any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate, period. Right? That's an act, that's a law of the United States. Right? That's the law of the United States. It prevails in every state in the United States. And that is the law that the president is relying on. Some of us who are lawyers may remember the Steele seizure case. Youngstown Sheet and Tube, where Justice Jackson, in his often quoted concurring opinion, laid out the limits of presidential power. And he said presidential power is at its lowest ebb when the president acts in defiance of Congress. But conversely, presidential power is at its highest when he acts with the explicit authority of Congress. What 212F does is give congressional blessing to the president having authority by proclamation to exclude people from the United States. And that's the authority for the travel ban. What about the courts? The Supreme Court, as anyone who's studied immigration law knows, has been very deferential to the political branches of government. Some would say extremely deferential, too deferential to the political branches. In 1977, in Fiala v. Bell, the Supreme Court said, "Our cases have long recognized the power to expel or exclude aliens as a fundamental sovereign attribute exercised by the government's political departments," that's the Congress and the executive, "largely immune from judicial control." And in the same case, the High Court said, "In the exercise of its broad power over immigration and naturalization, Congress regularly makes rules that would be unacceptable if applied to citizens." Right? So that's what the Supreme Court has said on this issue. And let me just say that in another case that was cited by the administration, in Kleindienst versus Mandel in 1972, which was an exclusion case, the government was trying to keep someone out of the country, and the court said, "We have had almost continuous attention on the part of Congress since 1875 to the problems of immigration and of excludability of certain defined classes of aliens." Congress is paying attention to this. They've been paying attention all along. And it is clear that the alien in this Kleindienst versus Mandel 1972 case, as an unadmitted and non-resident alien, had no constitutional right of entry to this country as a non-immigrant or otherwise, right? That's still good law as far as I know. Non-resident aliens outside the United States have no constitutional right to come in, and therefore the plaintiffs in Kleindienst versus Mandel were Americans who were trying to raise First Amendment arguments to say, well, wait a minute, we have First Amendment rights to have this alien come into the United States, and they got the district court to go along with them, as I recall. But the Supreme Court said, in deciding this case, that this court, without exception, has sustained the Congress's plenary power to make rules for the admission of aliens and to exclude those who possess those characteristics which Congress has forbidden, the Congress that enacted 212F. And it went on to say, the Supreme Court said, "Over no conceivable subject is the legislative power of Congress more complete than it is over the admission of aliens." Right? Over no subject does the Congress have more power. And that's the power that was exercised in the enactment of 212F. And in the end, the Supreme Court held in Kleindienst versus Mandel that we hold that when the executive exercises its power negatively on the basis of a facially legitimate and bona fide reason, right? Lawyers know that's a pretty low standard. It only has to be facially legitimate. It doesn't have to be really legitimate. It has to be facially legitimate. The courts will neither look behind the exercise of that reason, neither look beyond the exercise of that discretion, nor will the court test it by balancing the justification against the First Amendment interests asserted by the plaintiffs. Right? So that's the teaching of the Supreme Court, and reversing the lower courts. The Supreme Court has historically had no hesitation in asserting the fact that it's the Supreme Court. And the lower courts can take in all kinds of other consideration, but the Supreme Court jurisprudence is the rule. And as to all the travel bans, let me just say this, that the Supreme Court gave us a pretty clear signal on what it's thinking about these travel bans, you know, because they're watching what's going on in the lower courts just like everybody else. And on June 26, 2017, even though the second travel ban has since been declared moot, the Supreme Court went to the trouble of issuing a per curiam opinion, basically staying the preliminary injunctions that had been issued by the Supreme Court, by the lower courts. And you know, what is a per curiam opinion from the Supreme Court? It's been characterized as a unanimous opinion. That the Supreme Court unanimously stayed the preliminary injunctions issued by the two courts in the Ninth Circuit and the Fourth Circuit. And there was in part because they added language that said, except for those with a bona fide relation with a person currently in the United States. So there was that exception. But that exception was disputed by 3 of the justices. Why is there a second per curiam opinion? If there's a per curiam opinion, why do you need a second per curiam opinion? But a second opinion was issued by Justices Thomas, Alito, and Gorsuch. And this was on June 26, 2017. And they said, 3 of the 9 justices said they would have stayed the preliminary injunctions in full. Right? It was up to them. And they think the majority was mistaken in that it would prove unworkable, the exception that the majority tried to carve out. It would invite a flood of litigants. Well, that came to pass, right? So everyone wants to litigate those narrow exceptions, even though it's since been declared moot. That was a waste of energy. And those appeals would be directed to those same 2 district courts, quote, whose initial orders in those cases this court has now unanimously found sufficiently questionable to be stayed as to the vast majority of people potentially affected. So, and they cited Kleindienst versus Mandel as their authority. So I think, you know, the Supreme Court was giving us a little signal as to how they're inclined to rule on the travel ban. And, you know, who knows? I can't predict how the Supreme Court is going to rule. They're human beings. But if they follow their own precedent, and they have an institutional interest in following their own precedent, just so the Supreme Court doesn't seem completely politicized, that, oh, well, you get a different outcome if you have different personnel on the courts. There's no kind of neutral standard of justice. The Supreme Court is just a political body like Congress. So I think they recognize that, and they have historically said the reason we follow Supreme Court precedent is to maintain the integrity of the Supreme Court and to maintain respect for the High Court. So I think, you know, based on past precedent, they're going to sustain the whatever ban finally reaches the merits in the Supreme Court. And the Supreme Court has shown no hesitation to slap down lower courts in the area of immigration when the Supreme Court says over no area does the Congress have greater authority than over the admission of aliens into the United States. That's why we enacted 212F. And, you know, from a policy point of view, you could argue that if you're riding in a train, shouldn't someone have the power to pull the emergency brake? Right? Shouldn't someone have that power? And I think maybe 212F can be analogized to that. I don't think you can have a power that say, yeah, but depends on who the president is. You know, we don't like this president. We have no problem with other presidents having had 212F powers, but we have a problem with this president. You know, I don't think you can do that. I mean, he is the president. So I think the Supreme Court, following its own precedent, is is going to do that. It's no coincidence, I think, let me just wrap up, that the distinction, this binary distinction on immigration has played its way into the political arena. I mean, Donald Trump got elected, as we know, by raising an issue that nobody else was willing to raise, which is immigration. So that's one reason. The other reason is the Democratic Party has moved to the left. I called to your attention an important article in the Atlantic, July, August, called How the Democrats Lost Their Way on Immigration. And simply recalling, the Democratic Party, the most successful Democrats have been hardliners on immigration, like Bill Clinton, right? Bill Clinton signed those 1996 acts that really toughened up our immigration system. Bill Clinton gave a standard...
Equal time.
Okay. He gave a State of the Union address in what year? In 1995, and got a standing ovation for saying that we can't let immigrants abuse our legal system. President Obama was known as the deporter-in-chief throughout his first term in office. And one of the reasons he promulgated DACA in 2012 is because he was running for a tough re-election race. And that deporter-in-chief title kind of hurt him. So he needed to show, talk about political motivations for what presidents do. He needed to show that he wasn't, in fact, the deporter-in-chief, and that's why DACA came out. Okay, thanks very much. It's been a pleasure.
I have so many questions for the panel. And I especially want to put some questions that Professor WADHIA can answer, because she's the only person who actually listened when I told people I wanted them to talk for about 10 minutes or so. But before I do that, I want to share with you a smidge of what Professor Chen had to convey to the group, because I think it's really worth inserting at this point. And her focus here was going to be a little different. She was looking at the travel ban, and in particular, the refugee components of the various executive orders that Professor WADHIA mentioned, putting a sharp ban initially on refugee admissions, the later modifications to that, but focusing not on the impact on the people who are outside the United States, rather focusing on the impact of those orders on people who are already here. As part of her research, she'd done interviews with about 50 green card holders, including refugees, including folks who had entered the military as non-citizens, about their pathway to citizenship, about their legal consciousness, about what it meant to be a non-citizen, and whether they'll naturalize. And a consistent theme she'd gone in talking to those folks were what she referred to as defensive citizenship motivations for naturalizing, meaning naturalizing out of fear. Becoming a U.S. citizen because being afraid of what's happening in this country to non-citizens, fear that the Trump administration would change the rules, would take away green cards. These are senses she got among refugees, notwithstanding that they had relatively robust legal status. These are heightened legal consciousness among South Asian and most folks from South Asian and Muslim countries that were not subject to the travel ban, from Latinos, from Canadian high-tech workers. So she mentioned an interview with a green card holder from Mexico. Maria Cabrera mentioned the possibility that the president could declare no more green cards for legal residents. That was one of her inspirations for naturalizing. Guadalupe Castañeda, also from Mexico, described the president as disliking all immigrants, and that again motivated her to become a citizen. She was aware that Mexico wasn't a target of a travel ban, but said, gee, this was just the thin edge of the wedge. Who knew what happened what can happen next? Basma Magajadi from Iraq again, the Trump administration, she wrote, made her more determined to take the citizenship test. She felt more discriminated against within the U.S. after the election of November 2016. She described that as a further motivation for citizenship. She explained that she used to wear the hijab, and post-election, she got more discriminatory looks, discriminatory comments, decided, in fact, to change her traditional hijab and wear a cap because of that. Said she was disappointed. I came here to be more free and do the things that I want to do, and didn't turn out that way, but felt the need to become a citizen to protect herself. And a question then becomes, Professor Chen asks, well, how should we feel about that if that's an impact of the travel ban? Is that a good thing? Or is that a bad thing? It's no good thing if we think more people should become citizens. But Professor Chen answers is that ultimately what we're doing is a failure of integration, that we've got a federal immigration policy that treats enforcement on the one hand and immigrant and refugee integration on the other hand in ways that work at cross purposes, that aren't designed to treat refugees and other excludable non-citizens, that treat refugees and other excludable non-citizens as outsiders in ways that are incompatible with the treatment they deserve as future green card holders and future citizens. And this is leading us to a degraded meaning of citizenship with negative effects for the individual, for society, and ultimately for our own enforcement efforts. And, at this point, if the effect of the travel ban and other current U.S. enforcement actions is to feel folks with secure status in American society, that they're vulnerable in the U.S., that they're vulnerable because of the message sent by the Muslim ban, then I think that circles us back to what Professor WADHIA was saying at the very beginning about the post-9/11 efforts. It brings me back to Letty Volp's terrific 2002 article, The Citizen and the Terrorist, where she writes that what happened post-9/11 was the consolidation of a new identity category that groups together people who appear Middle Eastern, Arab, or Muslim, whether or not formally they're citizens, but nonetheless identifies people within that group as terrorists and sort of definitionally non-citizen. And so what we have here, and maybe this applies as well to the current situation, she writes, I'm just going to quote this phrase not from Chen but from Volp, the imagined community of the American nation constituted by loyal citizens is relying on difference from the Middle Eastern terrorist to fuse its identity at a moment of crisis. Okay, so that's my quick take on, or my quick personal version of what Ming Chen would have said if she were here. Having passed that on, I'm going to switch hats and I guess pose a question to the group at large. And the question goes something like this. The whole complex of issues surrounding the travel ban is just tremendously rich because it raises so many different questions, and I'm gonna try and rattle off 5 of them. One of them is the issue of presidential power and separation of powers. That to a large extent, what this is about, and as folks have pointed out, DACA was in many ways the same. What this is about is the extent to which the president can formulate a policy that not only that Congress has not articulated, that certainly in the case of the travel ban seems quite at odds with some of the policies Congress has articulated, and achieve that on his own as a matter of separation of powers. So that's one. Two, the issue we've been discussing of race, xenophobia, religious prejudice in America, and what that means and what role that's playing here. Three, call back to the earlier panel, federalism, because there are federalism aspects to the travel ban. If we go back to the first executive order, when it discusses refugee admissions, one of the points made by the first executive order, and this carries through, is a desire to Section 5G of the first executive order to give states and local jurisdictions more authority to reject refugee resettlement within those states. So that's three. Four, effective modes of immigration enforcement. From a purely instrumental perspective, does the Muslim ban actually make sense as a way of improving national security? And five, statutory interpretation issues. It's all very well to say that Congress has great power to articulate immigration law, but if Congress says that the executive is not allowed to discriminate on the basis of nationality in the award of immigrant visas, then that suggests that we should uphold Congress's authority and forbid the executive from discriminating when it comes to immigrant visas, which would be sort of bad news for at least a major component of the travel ban. So I guess with that long introduction, the question I want to ask you guys, starting with Professor WADHIA, is what frame of this controversy, whether it's one of the ones I just mentioned or some other, what's the larger lesson here? What frame of this controversy is one you think is not getting enough attention? And so let me, having posed that, pass that back on to the three of you.
Gosh, in one way I could say none of them are getting enough attention because I think different audiences are connecting to different frames in talking about this issue. I think race is one that hasn't received a lot of attention when we think about court analysis, because there are other frames and foundations that courts and lawyers are going to rely and use, like statutory arguments and the lemon test over this is really about the color of people's skin. I don't know how appealing I find the connection of DACA and the ban in presidential power and separation of powers. I don't know that it's the same argument, and here's why. I think DACA is a lawful use of executive branch authority, and I think the travel bans are not. That's the short reason why. And we do have congressional authority for a program or policy like DACA, and we can see it in Section 103 of the Immigration and Nationality Act, where Congress very clearly delegated the power of administering and enforcing immigration law to the Department of Homeland Security. We also have other sections of the Act and also jurisprudence by the U.S. Supreme Court that very explicitly acknowledges the concept of deferred action and the role of it in our immigration system. And so in that sense, the role of deferred action in our immigration system is just not a new concept to the Obama administration. And really what was new in that administration was more transparency and guiding criterion for officers to use in deciding who should receive it and who should not. And I think that there's been a lot of misapplication of something new when instead we're really thinking about more transparency. And I'll end by with the statutory interpretation, I think in the court of public opinion, the statutory interpretation arguments have not received a lot of attention because it's less sexy, right, than the First Amendment Establishment Clause ones. But I agree with Marty that I think the stronger arguments, even though I agree with the Establishment Clause ones, but the stronger arguments as a matter of law are the statutory ones. And I think that ultimately, if and when the plaintiffs win, it will be because the scope of 212F has been exceeded, slightly distinct, and 202A regarding non-discrimination in the issuance of visas has been violated.
And let me give you your turn next.
Yeah, I mean, I think the non-discrimination language does not trump 212F. The big idea of the American Revolution, right, and this country, is that the American people are capable of making their own laws through their elected representatives without a king. It was a revolutionary idea then. It's still a revolutionary idea today. We govern ourselves through our elected representatives. If we're not happy with what our elected representatives have done, we are free to elect new people to replace them, right? And we have that right periodically. But on the non-discrimination language, it was added in 1965. I don't have it right in front of me, but it says, except as otherwise provided in the code, right? And we have plenty of examples of discrimination post-1965 in the code. The green card lottery has been much in the news, right? Can you run a green card lottery and say no Mexicans need apply? No Filipinos need apply?
No.
Well, we do, right? Despite
actually
1965. Yeah, we run a lottery
those terms, we
that
don't.
says no Mexicans can apply. We don't even accept applications if you're Mexican or Filipino. We got enough Mexicans in this country, we say. We don't need any more. So we need more people from Uzbekistan, right, and other countries. And another thing is, like just legal immigration, because more people want to come every year than we're willing to give visas to, we make them stand in line, and so we have a line, and depending on your application, when we get around to you. But because of the per country caps that say, oh, no one country can take more than 7%, we say, oh, if you're Mexican or Filipino, you have to stand in a longer line. Just because you're Mexican or Filipino, right? You stand in a longer line, and sometimes Chinese, Indians, and Dominicans also have to stand in a longer line. It kind of depends on how long the line is at various times. No dispute about that, right? As long as the statute authorizes it, you can tell Mexicans to stand in a longer line, and we do. Right, from 1965 to this date. They wait longer for all categories of legal immigrant visas than other nationalities, right? That's okay, because Congress authorizes it, right? And so 212F, Congress authorizes it. So what's the problem, that I don't think that's determinative. On DACA versus the travel ban, I mean, yeah, they're both executive orders, but again, falling back on Justice Jackson's distinction in the Steele seizure case, if you act without the support of Congress, as was done on DACA, you're at the low point of presidential power. If you act with the explicit support of Congress, as the president did on the travel ban in light of 212F, you've got the explicit support of Congress. You're acting under their authorization. So yeah, they're both executive orders, but it seems to me the distinction cuts the other way.
So I don't want to talk about DACA here. I do want to note one quick correction about INA section 202A. I'm then going to toss it over very, very briefly to Marty because we're almost at a time when we have questions from the audience. I do want to make the point, though, that the 202A ban on discrimination in the issuance of immigrant visas on the basis of nationality does not have an open-ended except as elsewhere provided in the code. It has three exceptions. Except as provided in the per country limits of no more than 20,000 people per year for any one country. Except as provided in the preference categories, which covers the diversity visa. and except as provided in the definition of special immigrant in section 101A27. But those are the specific 3 exceptions that the statute gives to the non-discrimination ban. And that really strongly suggests that if Congress designated those 3 exceptions and those 3 exceptions only, that those are the only 3 exceptions Congress had in mind, and Section 212F was not one of them. Marty, quickly, and then we'll all be.
Very quickly, I think actually Professor Ting's presentation shows us what the problem is here for judges in this case. He's absolutely right when he quotes the language from the statute and from the Supreme Court precedents, although he didn't emphasize the words bona fide and didn't try to say that this was a bona fide act by President Trump. But what was missing from his presentation conspicuously, I don't want to assume anything, is any justification for what Donald Trump did here, or any suggestion that what he did here was consistent with what presidents have done under 212F before, during the regulations that preceded the congressional enactment, or in the 65 years after what Congress has done. It's a radical break that was done without any evidence of any problem, without any process, and without any real reason for the limits that he's put in place. And I think Professor Ting knows that. I think everyone in this room knows that. I think every judge knows that. And the question is what to do when you have a president who is deliberately exploiting the broad delegation and the broad deference that the other 2 branches have accorded the president over the years, and doing so for reasons that are, at best, irrelevant and not very compelling, and at worst, admittedly illegitimate. And that is a hard question, because if I were a judge, I wouldn't be inclined. It's not that Donald Trump is different, it's that he's done something very different from what chief executives have done for 65 years. And the question is whether that comports with the actual congressional intent and with the actual reasons that the court has traditionally deferred to the chief executive, or whether instead he has exploited those authorizations to do something that I think we all know is at least dubious, if not unconstitutional.
We can take as many questions as the organizers will let us take. So, Rachel.
So a challenge both to Marty and to Jan in sort of enshrining the plenary power doctrine. You referred to it as great, I think. Or maybe you stopped short after you said that, Marty, about basically the plenary power doctrine. To sort of, is this a time to look hard again at the plenary power doctrine, to go back to the origins of it, which were the 1880s, and those Chinese exclusion cases, which are profoundly racist. You read them today, and they are just, they smell bad. And they're the origin of plenary power doctrine, and they get repeated, and if you trace back Fiala v. Bell and Kleindienst v. Mandel, they all go back to those Chinese exclusion cases. And so that may be kind of the bona fide and facially illegitimate, that, you know, if it really smells bad, you know, you throw it out.
Yeah, I've thought a lot about the Chinese exclusion cases. As many of you know, we still teach the Chinese exclusion cases in every American law school in the United States. Every immigration law course typically begins with Chinese exclusion, in which the Supreme Court of the United States unanimously, without dissent, upheld a blanket exclusion of Chinese from the United States on purely racial grounds, and in which the majority opinion, the unanimous opinion, said, yeah, if Congress wants to exclude a particular race of immigrants from the United States, it's free to do so. And that is, the question is correct, that is the fountainhead. The reason we teach that first is because it's the fountainhead of American immigration law. If you can do that, what can't you do?
I will push back on that. We may all teach it, but I don't teach it remotely that way. As a matter of fact, what's remarkable is the court did not hold in the Chinese exclusion cases that the political branches could use race as a legitimate reason for exclusion. That was not one of the questions presented there. And what I said at the outset, I think, is one of the silver linings here, is that even the Trump administration has conceded that a policy that would be based on race or religion would be unconstitutional. That's the stronger version of the plenary power doctrine. Now, I think what you're referring to is what I call the weaker but still strong version, which is, but the judiciary will defer largely to the representations that are being made by the political branches about what are facially legitimate reasons and won't look behind what those two political branches are saying. And that is what's really teed up in this case, is whether the judiciary will look behind facially legitimate reasons and say, wait a minute. But I want to hear what SHOBA says.
Yeah, and this question wasn't directed at me, but I'll answer it anyway. And, you know, I don't think we need the Chinese exclusion case or the plenary power doctrine to strike down these travel bans. And because there's been framing around the jurisprudence in support of the plenary power doctrine, I think it's also important to identify and highlight the fact that we also have jurisprudence that makes cracks or breaks down the plenary power doctrine. And one case was highlighted twice today, Zadvedis, which was in 2001, where the U.S. Supreme Court cited to the Chinese exclusion case, but then also cited to a case called Chada, stating that we do have a plenary power doctrine, but that plenary power doctrine doesn't give unfettered discretion to the executive. And that is a similar standing and position that the courts have taken with regard to the travel ban. And so the constitutional limits of a plenary power doctrine are not new to the Hawaii and Maryland courts, but rather have been part of the jurisprudence in analyzing the scope of the plenary power doctrine in immigration law.
One more case I want to point to, and this is a point Marty made, but I want to highlight it, is that we talk a lot about Kleindienst against Mandel when it comes to the travel ban cases. But the folks who are attacking the travel ban are, at least in the context of this case, delighted to work with Kleindienst against Mandel, because Kleindienst against Mandel says the government's motivation, the government's stated reason needs to be bona fide. And for all the reasons that were set out earlier in this discussion, there are really ample grounds for argument that the state and national security claim here is not a bona fide claim.
Back in the corner.
Thanks. And as a certified non-expert in constitutional law, I'm not going to opine as to whether the Chinese exclusion cases, if they were presented today, would result in the Supreme Court upholding it. But I do want to point out that by the same logic, if Congress were to pass a law saying no more black people could enter the United States, all immigration and non-immigrant visas would be denied to anyone with black skin, by that same logic, that would be upheld as constitutional because the Equal Protection Clause doesn't reach beyond national borders and beyond U.S. citizenship. And these are, by definition, both. Similarly, we're no longer going to admit Muslims. Outright statement, which admittedly he made during the candidacy, but if he actually put it in the executive orders and proclamation, we hereby, I hereby order Muslims will no longer be admitted to the United States, the Supreme Court is going to uphold that. I don't think so. Here's why. Putting aside the fact that the times, they are a-changing, there's also the fact that international human rights law blatantly forbids that kind of discrimination. And we are parties to the International Covenant on Civil and Political Rights, which does not limit its holdings to persons either within the United States in terms of non-discrimination or persons who are U.S. citizens. Similarly, the Covenant on the Elimination of All Forms of Racial Discrimination, which we are also a party to, in which, according to both the executive branch and the legislative branch, we are in compliance with, forbids discrimination based on what's generally labeled as race, but which actually includes national origin, including in immigration policies. So, by virtue of being parties to that treaty, we have committed to non-discrimination. Now, admittedly, under the Supremacy Clause, treaties are only supreme until they've been later repudiated by Congress, but the consistent principle of U.S. jurisprudence has been not to read statutes in a manner that's inconsistent with our obligations under international law whenever possible. And so it's perfectly possible to read the Immigration and Nationality Act as consistent with our obligations under CERD and the ICCPR, the two treaties I just mentioned, merely by not allowing the government to discriminate in its immigration decisions based on arbitrary criteria of nationality or race without legitimate reason.
Can I respond to that?
Woman in the front row.
Let's let Denise talk, because we're already 7 minutes past our time.
I just wanted to sort of follow up on that last point and point out that the whole concept of the plenary power doctrine was really derived in the 1800s from international law at a time before the modern human rights era, when international human rights law became a way in which international law began to reach inside countries in terms of determining what governments can do with their own peoples and in terms of immigration policies and the rest. And so if you're going to rely on international law as the foundation of the plenary power doctrine, then you have to come up to the contemporary age and recognize that international law itself has changed in ways that would limit significantly the contours of a plenary power doctrine that supposes that states can do essentially whatever they wish inside of their borders or with decisions about who will come within their borders. And on Mandel, I just wanted to kind of follow up on that comment as well. I mean, it seems to me that that your suggestion that that case could actually be seen favorably here is really relevant, and it's in part the requirement of a bona fide reason. It's also sort of the suggestion that the ties there were just not sufficiently meaningful, and the Supreme Court itself, as you mentioned, alludes to this, that the analysis is different where there are more significant ties than those that you saw in Mandel, listening to speakers, and here almost every aspect of the Muslim ban affected and has affected very closely tied folks. Now with that, I do have one sort of lingering area of doubt, which is around refugees. It seems that for the most part, the analysis has been sort of hand in hand as to all of the various aspects of the bans. But as to refugees, you know, by statutory construct, every year the executive makes a determination about who will be admitted coming from abroad as refugees. And most of those determinations are largely national origin and even sometimes religion-based, and so it does seem to me that there the discrimination, the statutory discrimination argument is tougher if in terms of a ban based on national origin or religion. But on the other hand, I think there's a different statutory argument that's quite important that has been a little bit overlooked, which is the requirement that every year there be a presidential designation made and that be binding. And yet here, it was completely withdrawn and changed in the middle of the course of the fiscal year. So I wondered if there were any thoughts on those issues.
Excellent comment, and it raises a lot of issues, including the Lautenberg Amendment, which has been criticized as showing religious preference, another statute adopted by Congress repeatedly, showing a religious preference, explicit religious preference, never overturned. I just want to mention one other case, a more recent case, Naranji, 1979. I think it was a Second Circuit case during the Iranian crisis. President Carter ordered non-admission of Iranians solely on the basis of their Iranian citizenship. And the Second Circuit, when that was challenged, the Second Circuit upheld the president's power to exclude all Iranians from the United States. And they quoted from Heresy Eliades, an earlier Supreme Court case, and they quoted in 1979 that any policy towards aliens is interwoven with foreign relations, the war power, and the maintenance of a republican form of government. Such matters are so exclusively entrusted to the political branches of government as to be largely immune from judicial inquiry or interference. So, you know, there are other precedents out there where the high courts have shown extreme deference to presidential power.
Anyone else?
I just have to ask, does anybody argue that how can this be a Muslim ban when Indonesia and Pakistan were not included in the ban?
Or India, right?
Or India?
The biggest Muslim population in the world.
So the question of, well, why doesn't it include every Muslim majority country or the majority of Muslim majority countries is a question that was raised early in the litigation, even after Travel Ban 1.0. And I think the Virginia District Court judge said it best, but I'm paraphrasing, so you'll have to take it with a grain of salt, that we don't make decisions on whether the Establishment Clause has been violated through a mathematical exercise by whether all countries or some countries have been included. And then she goes on to talk about how, you know, I'm not making a determination about whether this is a Muslim ban based on math. I'm basing it on the driver behind the ban itself and then the countries that were actually included.
Well, that's an interesting question because then the question is raised, to what extent can a court use remarks made by a presidential candidate before he becomes president to interpret what he does as president?
So that's an important question, and I'll give you my take that I don't think it's only, I think it's been that plus. So I think when we have the conversation about using or referencing remarks made by the president prior to inauguration, we have to couple that with the fact that he still had on his website, well past inauguration, a proposal to shut down Muslim immigration. And tied together, and you'll see this in some of the judicial opinions striking down or issuing an injunction around the bans, that it was the sequence of events that cumulatively lead to the conclusion that there was sufficient animus to lead to a potential violation of the Establishment Clause. So I think those statements are quite significant even today.
I would only add on that last point, Donald Trump doesn't want us to forget those statements. He wants his supporters to remember that he made those promises, and he wants to say, I'm making good on them now, and he sends signals to that effect all the time. Are we taking more questions? Pardon?
Let me just say, I don't disagree with what you just said. I mean, I think Donald Trump is a ratings guy, and he's like looking for whether everything he says can get ratings from the American people or not. I mean, I think about his challenging the NFL players kneeling. I mean, what's that all about? You know, I mean, but it's a ratings thing. He knows it plays well among certain populations in the United States, so he's for that. Pence's walkout from the NFL game. What was that all about? That was play acting, but it's going for ratings, you know. And so, yeah, we've got a president that's like doing stuff just because he thinks it'll get ratings.
And should the judiciary defer to that?
Yeah.
So, John, I did promise I'd like to close, if you'll indulge me for a second, because I think it ties together all four panels because it really struck me, I hope it'll strike you, with President Truman's veto statement on this 1952 statute, because it really resonates. He wrote, I'm sure with a little more time and a little more discussion in this country, the public conscience and the good sense of the American people will assert themselves, and we shall be in a position to enact an immigration policy that will be fair to all. The country-by-country limitations that were in the 52 Act create a pattern that's insulting to large members of our finest citizens and foreign to our purposes and ideals. The greatest vice of the present quota system is that it discriminates deliberately and intentionally against many of the peoples of the world. Its purpose was obviously to cut down and virtually eliminate immigration from Southern and Eastern Europe. A theory was invented to rationalize this objective. The idea behind this discriminatory policy was, to put it baldly, that Americans with English or Irish names were better people and better citizens than Americans with Italian or Greek or Polish names, and that people of Western European origin made better citizens than Romanians or Yugoslavs or Ukrainians or Hungarians or Bayites or Austrians. Such a concept is utterly unworthy of our traditions and our ideals. It violates the great political doctrine of the Declaration of Independence that all men are created equal, denies the humanitarian creed inscribed beneath the Statue of Liberty. I know Stephen Miller has a new theory of the Statue of Liberty. Give me your tired, your poor, your huddled masses yearning to breathe free. It repudiates our basic religious concepts, our belief in the brotherhood of man, and the words of St. Paul that there is neither Jew nor Greek, neither bond nor free, for ye are all one. The basis of this quota system was false and unworthy in 1924. It is even worse now, 1952. At the present time, it keeps out the very people we want to bring in. It is incredible to me that in this year of 1952, we should again be enacting a law, such a law as to slur on the patriotism, the capacity, and the decency of a large part of our country. The time to develop a decent policy of immigration, a fitting instrument for our foreign policy, and a true reflection of the ideals we stand for at home and abroad is now. Now was 65 years ago.
On that note, let's move to the wrap-up.
I'd written about 4 or 5 takeaways with which I will not bore you. Just a few parting thoughts. I deliberately selected a red, white, and blue tie to wear today, but it was only about halfway through the day that I realized that the colors are interwoven. I'd like to think that we've stayed true, and we can remain true to the Yale premise that Senator Levin talked about as we began our program today, that we came here certainly with some ideas and some very important principles with which we thought we could hold true. But I hope some of the things that we heard today did challenge some of our premises, did get us to rethink certain ideas, to see to what extent we might seek common ground, and to see, to think about to what extent it's important for us to hold our ground on certain important premises. I'd like to think that the pluralistic dream is alive. It doesn't remain so without struggle, but it's always been a struggle. We see that pluralistic dream in this room, in this city, and we can only hope that it prevails, but we must do more. We have to work, I think, to see that it prevails. Our thanks to all of the panelists. We've had some splendid panels. We've had 4 splendid panels today. Our thanks to the audience. You've been a terrific audience, and we really appreciate that. So we wish you all safe travels, and at the risk of stepping over the boundaries between church and state, may God bless.